compliance at BackTrack. A few housekeeping things before we start. The live webinar is approved for one HRCI General Recertification credit. If you're interested in the credit, be sure to complete the survey at the end of the presentation. Your certificate of attendance will be emailed to you later this week. If you have any questions for our presenter, please use the question pane in your screen, and the questions will be answered at the end of our webinar. And this webinar is being recorded, and a link will be sent out to everyone who registered for it for viewing at a later date. And please note the recorded webinar is not eligible for the HRCI credits. And our presenter once again is John Hyman, partner at Myers Roman and noted blogger and author in the labor and employment arena. We're happy to have him share his expertise and knowledge. And I'll now turn the webinar over to John. Thanks, John.
Thanks, Laura. Good afternoon to everybody, or good morning, I guess, if you're sitting in parts west of where I am in Cleveland, Ohio. It's good to be with everyone today to cover a pretty important topic, legal hiring. And before we get into the meat of our hour together today, I want to make a brief note of what we're not going to be covering. We are not going to be covering the Fair Credit Reporting Act and background screening regulatory and legal requirements. We're not going to be covering criminal background checks. They were the subject of our first and second webinars of the year. And if you were not, couldn't make one of those or haven't yet seen it, number one, shame on you. And number two, you can go to BackTrack's website and you can find the webinars archived there for your viewing pleasure and educational betterment to learn all you want to know about the Fair Credit Reporting Act and legal background checks and criminal background screening and what the EEOC, the Equal Employment Opportunity Commission, has done in that area from a regulatory standpoint recently. So with that little bit of housekeeping out of the way, we can now turn to what we are going to talk about today, which is legal hiring and some of the pitfalls you can step into, I think really unintentionally. I don't think, I mean, I've been doing this representing companies in the employment arena for almost 2 decades, and in my experience, the overwhelming majority of employers do not intend to set out and discriminate. Most employers want to do the right thing by their employees, which starts from the hiring process, which is an employee or potential employees kind of first kind of look at an organization. A company is not trying to set out and discriminate. Having said that, I mean, there was one example not too long ago of a case that was filed here in Ohio with a company that had their recruiter label applicants, and by label I mean she would every applicant was given a nickname. Things like Chocolate Cupcake would be a black female applicant, so then the company would know not to pass that person through to the hiring process or further in the hiring process because they didn't want to hire any black females for a particular position. So when I say most companies don't, there are some companies out there that look just don't want to do what the law says and frankly morals and what's right say you're supposed to do. But I think by and large most companies are not trying to discriminate against job applicants when they're hiring. But having said that, there are some pitfalls that companies can fall into if they are not careful in how they actually go about their hiring, their recruiting and hiring process. And it starts right out with the job interview. The very first, you know, your first look-see at an applicant when they sit down across from a hiring manager or an interviewer in a job interview situation, and you engage in this back and forth. And look, there is lots of good information you can learn about an individual through a job interview, and there's a lot of things that you just absolutely 100% flat out can't ask. And it's all based around our equal employment opportunity laws, what our EEO laws say about hiring, or say about rather discrimination and the classes of that are protected from discrimination. So we know that you can't discriminate based on age, national origin, religion, disability, race, sex, what have you. And there are questions that an interviewer can ask an applicant during a job interview that would shed light on one of those protected categories, and because it sheds light on one of those protected categories, it's a question that just can't be asked. And I want to run through some examples to kind of give you a sense of what I mean. Because if the people that you have interviewing for your companies are not trained on these issues and aren't skilled in what they can and can't ask, they very well may treat the interview as a, look, we want to find out everything we possibly can about this person before we hire them to make sure they're the right fit for the organization. And while that is true to a degree, there are limits on what everything means. And as I said, those limits are kind of set by the categories that our EEO laws protect from discrimination. So for example, we'll go through some kind of questions that should not be asked to kind of illustrate this point, and then questions that you can ask. And the questions that you can ask are all based on legitimate criteria that you want to know before you hire someone without getting at this protected information. So what does this mean? Let's take age as an example. It's illegal not to hire someone if they're based on their age, if they're age 40 or over. And so questions like, obviously, how old are you is a big no-no. That's the obvious, right? Because you don't want to know how old someone is. But there's other questions that could shed light on how old someone is. So just like how old are you will tell you how old a person is, so will a question like, what year did you graduate from high school? Because you can just do the math. People are typically age 18, give or take, when they graduate from high school. And so if you subtract the graduation year from the current year and add that to 18, add that difference to 18, you will get a ballpark age of a job applicant. And for that reason, question like, when did you graduate high school, a big no-no. Other questions that also could reveal someone's age are things like, how many years until you plan to retire? How many years seniority did you have at your prior company? Again, questions that would tend to allow someone with some simple math to get a ballpark idea of how old someone is, just not questions that should be asked. What is legitimate to ask when we're talking about age? Not how old someone is, but whether or not someone is, frankly, eligible to work at all. So, for example, if hired, can you submit a birth certificate or other proof of age so that we know that we're not violating child labor laws? Or instead of how old are you over the age of 18? Again, eligible to work without raising any issues under any child labor laws or child labor regulations. So that's age, for example. Another no-no would be in the area of national origin. Someone has to be eligible to work in the United States. We have an I-9 that's filled out, so we know that someone is eligible to work in the United States, and that's fair game. That's a fair question to ask. Are you eligible to work in the U.S.? What's not fair to ask? What country are you from? Geez, that's a really interesting accent. Where were you born? Where were your parents born? Things like that. Just questions that, frankly, common sense, I think, and maybe I'm tainted by the fact I've done this for so long, common sense should dictate are questions that you should stay away from. But nevertheless, things that you want to make, conversations you want to make sure you're having with your people doing job interviews, so they know to stay away from questions like that. Disability is another area where there's a whole bunch of landmines that you can step on from a disability discrimination perspective. Questions that you should ask, that you want to be able to ask. You want to know, again, not what someone's medical issues are, but whether or not someone can perform the job. And so you can ask questions like, these are the essential functions of this position. Do you know of anything that would limit your ability to perform any of those essential functions? And then if the answer to that is yes, then the follow-up would be, what accommodations can we make that would enable you to perform those job functions? Another question you could ask someone is, look, this is an essential function of the job. Can you describe to me how you would go about doing that? Those are questions that get at one's ability to do the job, not one's medical protected disability. Questions that you don't want to ask what is your medical history? Do you have any medical conditions or disabilities? If so, how will they affect your job performance? Have you ever filed a workers' compensation claim? Do you have a history of drug or alcohol addiction? Addiction is a protected disability. What medications are you taking? We're going to talk more about these issues in the context of pre-employment screenings in a little bit, but to make the point, there are, again, in the surrounding the area of disabilities, a whole bunch of questions that you just flat out just do not want to, ask applicants during a job interview process. By the same token, there are other stereotypes to avoid during the hiring process. You want to avoid stereotypes, whether spoken stereotypes to an applicant or written comments in evaluations or what have you, that would lead to a potential inference of discrimination. For example, not wanting to hire a married woman because she is of childbearing age and may take a leave to have a child. Making gender-based stereotypes of how men or women should appear or behave in the workplace. So making a comment that a woman is too macho or a man is not assertive enough. Assuming that those that are younger have higher energy levels, those that are older might have peaked or run out of gas. There is, I read an article, I don't know, a month or two ago, asking whether hiring for a digital native is discriminatory. If you place an ad for a job and ask for the job to be filled by a digital native, that is someone who grew up with technology, are you is that ad in and of itself evidence of a discriminatory animus based on age, because those that are digital natives will be younger. Those who grew up with grew up with technology will be younger than those that did not. And are you screening out based on age individuals who are over the age of 40 and maybe didn't grow up with technology the same way those in Gen Y or Gen X have? So, job interview questions are a real prime area of potential litigation for people that don't get hired for jobs. If your interviewers, those doing the screenings, are not really well trained on what to ask, what not to ask, and more importantly, so they understand why certain questions should not be asked. I want to now talk about accommodations in the hiring process, and there's two types of accommodations we're going to talk about because there's two different laws that require accommodations in employment. We have Title VII, which requires accommodations for people's religion, and we have the Americans with Disabilities Act that requires accommodations for people's reasonable accommodations for people's disabilities. And I want to talk about both, but I want to start with the issue of religious reasonable accommodations, because this has been very much in the news lately with the recent Supreme Court decision in the EEOC versus Abercrombie and Fitch case. A little bit of background on the case. Abercrombie and Fitch has what it calls its, quote, look policy. That is, Abercrombie believes, and it's a formal policy that the stores have, believes that you need to appear a certain way, you need to fit a certain image to sell their clothes in their stores. That Abercrombie is not just selling clothes, but they're selling an image, a look, and if you don't fit that look, then you're not qualified to sell Abercrombie clothes in one of its stores. A young woman went to apply for a job in an Abercrombie store. She was wearing a hijab, that is the traditional Muslim head covering, and she was not hired for the job. She sued. The case went all the way up to the U.S. Supreme Court, and ultimately the Supreme Court sided with the employee, saying that if the need for the accommodation, that is the need for the accommodation this applicant wanted was an exception to Abercrombie's look policy, to say, look, I'm otherwise qualified to hold this job, and if you don't make it, and so the accommodation I'm looking for is an exception to your look policy to allow me, who was otherwise qualified, to work in your store, despite the fact that I don't necessarily meet the letter of your policy as to how I'm supposed to look because of my religious attire. The court basically said, look, if the need for the accommodation was a, quote, motivating factor in the employer's decision, regardless of whether the employer had actual knowledge of the religious practice or its need to be accommodated, then it's religious discrimination in the hiring process. Discrimination in the hiring process has occurred. The court said, look, intent here doesn't really matter. We don't care whether or not the employer intended to discriminate. Here, the employer really should have known that this employee who was wearing a religious garb needed some kind of accommodation for her religion, and because the employer did not even consider an accommodation and just rejected the candidate as not falling outside of this look policy, this employer violated Title VII by not offering that accommodation. What do you do when even someone where it's readily apparent that someone needs an accommodation for a religion comes in to apply for a job? Let's say, for example, you have the employee who wears a hijab, and that doesn't meet your look policy. Or let's say you have someone who is, by outward appearance, looks like an Orthodox Jew. They come in the long black coat and the black hat and the beard and the payas, the long curly sideburns down the side, and you're a business that works Saturday hours, and you're pretty certain that this individual is not going to be able to work a Saturday for you because they appear, at least outwardly, to be an Orthodox Jew who's not allowed to work on the Sabbath. What do? What you shouldn't do is flat out ask the employee, ask the applicant, the individual, about their religion. I mean, think back to what we talked about a few minutes ago. Even if it's obvious, you don't want to just come out and say, you appear to be Jewish, can you work on Saturdays? Instead, you want to do what we talked about before. If you think an applicant or an employee's religion might interfere with his or her performance of the essential function, with an essential function of the job, explain that essential function and ask if the employee needs an accommodation. So ask, number one. Number two, you want to communicate. If the individual needs an accommodation, you want to engage that individual in the interactive process. You want to have a conversation with the applicant, with the individual. You want to explain your policy for which an exception will have to be made, whether it's the look policy or work hours or what have you. You want to talk through possible accommodations that exist and then decide which accommodation, if any, is appropriate for your business and that individual. And then third, you want to educate your workers about these Title VII requirements. Does your organization have a written policy on religious accommodations, for example? If not, it's probably a good idea to have one. And as we know, having a policy, however, is not enough if it's not communicated to your employees, explained to your employees are trained on it so that they understand what the policy means, how it operates, that you can enforce the policy if necessary if you have employees that are violating the policy by not offering or considering these accommodations in the hiring process. The other statute that provides for accommodations, provides for reasonable accommodations in the application or hiring process is the Americans with Disabilities Act. If, for example, and the rules in terms of the accommodation process is the same. You want, whether it's a religious issue or a disability issue, you want to do the same thing as you did with the religious discrimination, religious accommodations. You want to ask through an explanation of the essential functions, whether they can perform the job. You want to communicate in this interactive process, and then you want to make sure that your employees involved in this process are educated on the process. The rules are the same. The issues are slightly different because, number one, it may not be apparent. Number one, we're not really necessarily talking about exceptions as we do when we're talking about religious accommodations. We're often talking about exceptions to work rules. In the disability discrimination context, we're sometimes talking about making things more accessible for individuals. So, for example, having written materials used in the hiring or interviewing process available, not just in writing, but in accessible forms, such as large print, braille, or audio tape. Having readers or sign language interpreters available. Ensuring that interviews are being held in accessible locations, and that you're not holding your job interview, for example, on the third floor of a four-story walk-up, that someone who's in a wheelchair, for example, or is less able than their mobility is able to actually get to where the interview is being held. Maybe if you're giving some kind of screening test, extra time for someone that might need it because of a disability, a learning disability, for example. All examples of types of accommodations that businesses have to consider for individuals with physical or mental disabilities that are protected under the Americans with Disabilities Act. I don't want to belabor the point of disparate impact too much. Moving on to the next area of concern, we covered this a lot in our last webinar on criminal background checks, but there are a whole bunch of neutral policies from a screening perspective that companies apply all the time that the EEOC and federal courts are taking a long, hard look at, not because they intentionally discriminate against African Americans or other minorities, for example, but because they tend, through their neutral application, to nevertheless impact one group, a minority, more greatly than a non-minority. And so criminal background checks is one, because African Americans and Hispanics are incarcerated at a much higher rate than Caucasians. Credit checks are another of areas that areas of concern for employers and how they carry out these otherwise neutral screening tools. If this is something you're interested in hearing more about, I suggest you go back and listen to the last webinar where we really talked about this disparate impact issue in depth. But just to make the point, if some kind of hiring criteria has an adverse impact on a protected group via a relevant statistical analysis, then it is going to be at least facially illegal as under the disparate impact analysis, unless an employer can show that it is job related and consistent with business necessity. And so, for example, depending on the job that you're hiring for, you may be able to nevertheless use a criminal background as a hiring criteria, even though it has a disparate impact on minorities, because the particular position for which you are hiring, that a particular crime or series of crimes is related to that job, and it is necessary for your business not to hire someone. Obviously, if you're running a school, for example, you're not going to hire a registered sex offender to be around kids, for example. So just be aware that there are these facially neutral screening tools. One I just read about, social media accounts, for example. If you were to say, we require you to have a Facebook account to work here, there might be, for certain digital media, there might be something from a marketing perspective that a company might want to do. Be aware, however, that Caucasians are disproportionately overrepresented on Facebook. There's many, many, many more whites than blacks on Facebook, and for that reason, a must-have a Facebook to work here policy might have a disparate impact. Based on race. Medical examinations. Another screening tool, another pre-employment testing that many companies do, but you got to know the rules to how to do this right. There's basically three different times when a company can conduct a medical examination: pre-offer, post-offer, and then post-hiring. And only from the hiring perspective, really only one of them is necessarily legal, and that is the post-offer pre-hire test. So let's break it down. Unless a conditional job offer has been made, it is absolutely per se illegal to give any medical test whatsoever to anyone during the hiring process, period. Pre-conditional job offer. Once a conditional offer of employment has been made, you are allowed to give any medical test you want, provided that it is given to all people within the same job category across the board, period. Once someone is hired, once they become your employee, so they've accepted the offer, they've started working, at that point, you're only allowed to give a medical exam if it is job-related and consistent with business necessity. Otherwise, you have violated the ADA. The other point to make about medical exams is the importance of confidentiality. The Americans with Disabilities Act requires all medical information to remain confidential, kept, for example, in files separate from personnel files. I can't tell you how many times in litigation, I get a plaintiff's personnel jacket from an HR department, and then mixed in the personnel file is medical leave of absence request, doctor's notes, workers' comp information from an injury, talking medical information, all a huge no-no. The ADA requires that this information be kept in a separate medical file, not be intermixed with the personnel file, and then that the information is disclosed to supervisors and only on a need-to-know basis. So number one, the tests are limited in when they can be done, and number two, there are pretty strict limits on how the information is stored and maintained within the workplace. Another point I want to make is that I'm only speaking now to Ohio because that's where I work and that's where my practice is. Ohio has a specific law that prohibits employers from shifting the cost of pre-employment medical examinations to the employees. It's Ohio Revised Code 4113.21, which is called, the statute is called, employees shall not be required to pay cost of medical exam, and the statute doesn't say much more than that. It says no employer shall require any prospective employee or applicant for employment to pay the cost of a medical examination required by the employer as a condition of employment. So if you require an employee or an applicant to go get one of these pre-employment medical examinations, it is absolutely, under Ohio law, illegal for you to shift the cost of that examination to the employee or applicant. Drug testing is a specific subset of this pre-employment medical testing. When I say drug testing, the slide really should say drug and alcohol testing. There is two different types of tests, drug tests or alcohol tests that you can give to employees, pre-employment, during employment, what have you. Only one of them, however, is a medical examination. The Americans with Disabilities Act, believe it or not, does not regulate testing for illegal drugs, because testing for illegal drugs, marijuana, cocaine, or marijuana if it's illegal in your state, cocaine, heroin, whatever, doesn't relate to any medical condition, so it's not tied to, and because of that, the EEOC and courts take the position that drug testing is not a, quote, medical exam under the Americans with Disabilities Act. However, and this is, I'm not sure this makes sense, but Blood, urine, and breath tests to check for alcohol use, however, are considered medical examinations regulated by the Americans with Disabilities Act, which means that during employment, pre-hire you can't. During, post offer of employment, once you make a conditional offer of employment, you can require anybody to take an alcohol test. I'm not sure why you would. And then during employment, it's only if it's job related and consistent with business necessity, such as if you have a reasonable belief that an employee might be under the influence of alcohol at work. What about random testing, for example? Random drug testing would be fine because, again, drug testing not covered by the ADA. Random alcohol testing, however, because the alcohol testing is covered by the ADA, regulated by the ADA. Random is not job-related or consistent with business necessity, and therefore random alcohol tests of employees are illegal under the Americans with Disabilities Act. It's okay to test someone, post-accident, reasonable suspicion, you think someone might be drunk at work, that's okay, but just a random alcohol test of your workforce, facially illegal under the Americans with Disabilities Act, because random cannot be, at least according to the EEOC, job-related and consistent with business necessity. What about prescription medications? What about testing for legally prescribed drugs? Let's talk about that for a second, because that raises a slightly different issue than the testing for illegal drugs, because testing for a legally prescribed drug could potentially reveal protected medical information. Whatever the drug is prescribed for is going to tell you what potential conditions are being treated with that medication, and as a result could lead to the disclosure of otherwise protected medical information. So therefore, testing for legally prescribed drugs is likely going to be a medical examination under the Americans with Disabilities Act, and so for that reason, you need to make sure you are following the rules for medical exams under the ADA, and making sure we're following those 3 different time frames when you can or cannot test and how you can test, and then also making sure that you are maintaining the confidentiality of that medical information that could be revealed by those potential drug tests. One other issue I want to talk about briefly with drug testing deals with what do you do if an employee, for example, can't give you a sample because of a medical condition. A case that was decided in Southern Ohio just this spring, Lucas versus Gregg Appliances. Gregg Appliances, the employer, maintained a drug-free workplace policy which required periodic testing of employees. Again, drug testing, illegal drugs, not illegal under the ADA, totally permitted. Gregg Appliances, the employer, promoted the plaintiff, Chris Lucas, to a general manager position and made that promotion contingent upon him passing one of these drug tests. Unknown to the employer, however, this Chris Lucas, the employee, suffered from paruresis, which was news to me as to what that is, but that is a very fancy word for shy bladder syndrome. He claimed he couldn't urinate in public bathrooms and would often hold his bladder throughout the entire workday to avoid having to use the bathroom at work. He also admitted, though, that if he had to go so badly, his desire not to wet his pants at work would overcome his fear of public urination, and he would, in fact, go in the bathroom at work despite this shy bladder syndrome. Be that as it may, Gregg Appliances, the employer, says to Lucas, look, you got to take this drug test to get your promotion. He goes to the drug clinic. They give him a little vial, a little cup to urinate into. He panics because of the shy bladder syndrome and flees the drug testing site without A, telling anybody why, and B, without giving the specimen. The testing facility reported back to the company that Lucas left the collection site before completion of the drug test. Ultimately, he was terminated because he did not qualify for the promotion for not completing the required drug test. What did the court do with this case? The court in this case actually dismissed Lucas's lawsuit because the employer had no knowledge that Lucas had this disability. He never told anyone at the company before taking the drug test, or even after he failed to complete the drug test, that he had this shy bladder syndrome. He only told anybody when he was called on the carpet for not taking the drug test and was about to be fired, and he said, "Oh, by the way, I can't pee in public," and by that point it was too late. If the disability is obvious, you may have to consider accommodations even if not asked for, but here there's no way a company's going to know that this guy has shy bladder syndrome. It's not an open or obvious disability. It's incumbent upon the employee to let the employer know, and it's also incumbent upon the employee to request the accommodation. The employee did neither here, and therefore, at the end of the day, he lost his ADA lawsuit. However, the case could have turned out very differently had Lucas just said before he went for the drug test, "Look, I have this shy bladder syndrome. I can't pee in public. How else can we make this work?" And they could have, they could have done a hair test. They could have done a blood test, other ways to test without having him pee in a cup. But he never asked, he never told, and therefore no accommodation in this case was required. Another type of potential medical examination protected by the ADA is personality tests. Read an article, if I can pull it out for myself for a second, in the Wall Street Journal back in April, talking about how prevalent these tests have become. 8 of the top 10 employers in the country use these kind of pre-hire personality tests for at least some of their positions before making hiring decisions. Let's see, in 2001, 26% of U.S. employers are using these tests. By 2013, the number had jumped to 57%. So, more than doubled the number of employers that are using these personality tests to screen out people that they don't think fit their culture, or otherwise don't exhibit traits that they don't want working for them. The question is, are these tests legal? And again, keep coming back to this issue of medical examinations under the ADA. It really hinges on whether or not the personality test is a medical examination covered by the Americans with Disabilities Act. If it's not a medical examination covered by the ADA, then there's no legal limits placed on how employers use these tests. If it is an ADA medical examination, however, again, prior to an offer of employment prohibited, after an applicant is given a conditional job offer, but before he or she starts work, these tests are permitted without any relationship to the job at all, as long as the employer does so for all entering employees in the same job category. And then once employment begins, these personality tests are permitted only if they are job-related and consistent with business necessity. This is a case that is very, has been seldom litigated. The leading case is now 10 years old, out of the 7th Federal Circuit Court of Appeals, which covers Illinois, Indiana, and that part of the Midwest. Carrico versus Rent-A-Center. In that case, the Carrico Court, the 7th Circuit, concluded that the ADA, now again we're going back 10 years, covered the MMPI personality test as a protective medical exam. The MMPI at the time asked questions that could help identify some mental disorders or impairments. The MMPI contained medical diagnoses such as paranoid personality disorder, and for that reason the court concluded that it was a protected medical examination. The MMPI, I am certain, has modified in the last 10 years. There are other personality tests out there. Your mileage on these tests will vary, but it really depends. The issue as to whether or not these are protected medical examinations are going to hinge on, are the questions or answers revealing some kind of, have the potential to reveal, mental disorders or mental impairments, which would be a medical examination, or is it merely a psychological test to measure personality traits like honesty, personal preference, personal habits, and what have you, which would not be a medical examination covered by the ADA. If you are one of these 56% of employers that are using these personality tests to help screen applicants, I suggest that you have a conversation with the screening company to find out exactly what type of information they're screening for, and get a sense to get a sense of whether or not it is medical information or personality traits that are being revealed by these personality tests. Polygraphs are another type of screening tool that employers use. Very, very limited in how companies can use polygraphs. Federal statute, the Employee Polygraph Protection Act, regulates the use of all devices that are used to render a diagnostic opinion as to the honesty or dishonesty of an individual, which includes polygraphs, deceptographs, voice stress analyzers, or psychological stress evaluators. It applies to all private employers, and it prohibits employers from requiring, requesting, suggesting, or causing an employee or prospective employee to take or submit to any lie detector test, using, accepting, referring to, or inquiring about the results of any lie detector test of an employee or prospective employee, or discharging, disciplining, discriminating against, denying employment or promotion, or threatening to take any of that action against an employee or prospective employee for refusing to take one of these polygraph tests, etc. So typically in the hiring process, I'm going to say almost across the board in the hiring process, the use of polygraphs is not gonna fly under the Employee Polygraph Protection Act. There are limited exceptions. One exception covers the prospective employees of armored car and other similar security companies. Another covers prospective employees of companies that manufacture controlled substances. In those cases, it's okay to use a polygraph as part of your hiring process. Otherwise, polygraphs and other of these honesty or dishonesty diagnostic tools are going to be forbidden to be used in the hiring process. So just be aware, if you are considering using one of these tools, unless you fall in one of those specific industries, very, very, very highly regulated, very suspect, and not a good idea really to use, period. The last issue I want to cover in the little time we have left, and then I do want to leave some time for questions if people, if there are any questions out there in the listening audience, is what I call the Google background check. It is the kind of informal, instead of or in conjunction with a more formal background screen on a job applicant. You go on the internet, type a job applicant's name into the search bar in Google or on the search bar on Facebook, and you kind of see what information you get back. There are, services out there, Reputation.com that will, for a fee, scrub people's online reputations. There's whole industries that have popped up with making sure that people are satisfied with what their reputation looks like online. And look, there's a whole bunch of, good quality information about job applicants that's out there that you as a prospective employer might want to learn before you hire someone. You might want to know how does someone communicate online. You might want to know, does someone exhibit good judgment in what they choose to post? You might want to know, does someone appear to be a good fit for our culture based on what they post online? You might want to know, has someone ever written a bad review or trashed a former boss or former company online? You might want to know, does someone exhibit poor judgment by posting inappropriate photographs? Does someone post harassing or racist messages? You might want to know, does someone divulge confidences of a prior company? All things that either might qualify or disqualify someone from employment depending on what's posted online. And so, resume comes across your desk, the resume says John Doe, you type John Doe into the search bar on Google, you get a range of hits. Obviously, the less common the name, the more accurate the results are going to be. And then you figure out kind of what you have. How can this go wrong? I mean, what's the downside of doing this? Here's the downside of doing this. And I'm going to use a personal example because it really perfect and drives home the point. I have a now 7-year-old son at home who was born with a genetic condition called Noonan syndrome, which gives him a host of medical issues. He has a congenital heart issue. He is short in stature. He has asthma. He has celiac disease. He has a bleeding disorder. Just a whole bunch of medical conditions related to this particular genetic disorder that he was born with. When he was 2 years old, he spent 19 days at the Cleveland Clinic following complications following a medical procedure he had, and it was in February of 2011. He was in the clinic for 19 days, and so it's Valentine's Day. I'm sitting in the hospital room at the clinic. He's taking a nap. And I'm trying to figure out what to purchase, what to get my wife for Valentine's Day. It was February 12th or 13th, and Valentine's Day is coming up. And we're not, as a couple, we're not huge Valentine's Day people, but I wanted to do something nice for her because it had just been just a crappy month. And so we had already purchased the Cleveland Clinic souvenir shirt in the gift shop when we had spilled something on the shirt she wore to the hospital one day, and I didn't think she really wanted another, the gesture of my romance to be another a T-shirt to remind her of what a horrible time we had in the hospital. But what I did do for her was set up a blog for her. By that point, I had been blogging now, I think, for 3 years, and I thought she was a stay-at-home mom at the time, and it would be good for her to kind of write to get things off her mind, and then to reach out to other parents that were going through similar issues as we were with Donovan. And so I sat in with my laptop in the hospital room and set up this blog for her, and that was her Valentine's Day gift. And before she went back to work a couple of years ago, she blogged pretty regularly and wrote about our family and what was going on, but then also wrote a lot about Donovan and medical issues and doctor's appointments and other things going on in his life. Now, if, when she decided to go back to work, if an employer typed her name into Google, found her blog, which is not hard to do, just based on her name, frankly, found her blog, and then read all about these medical issues before hiring her, this employer might think to itself, oh my God, what are we getting ourselves into? This person's going to drive up our medical insurance costs, might need all this time off to deal with these medical issues, is not going to be a focused employee. This isn't someone we want to hire, period. Next applicant, please, which would be absolutely illegal. It would be illegal under the ADA as discriminating on someone based on their association with someone with a disability, and it would be discrimination under the Genetic Information Non-Discrimination Act for discriminating against someone based on their association of some close family member's genetic information. And frankly, it might be sex discrimination too if this employer, if they would have learned this information about a father, would they consider that the same as they would as information about a mom? Would they say, well, this is the mom's job to be the caregiver, and we're going to treat that differently than if it was a father who had a child with the same issues? So maybe sex discrimination too, and now this person, not hired, now has 3 potential discrimination claims against his company because they, while good intentioned to do these searches, went about doing them entirely the wrong way and then used the information incorrectly. And frankly, even if they don't use the information incorrectly, if this individual is not hired, have they nevertheless opened themselves up to liability to have to prove a negative that no, yeah, we did these searches, but no, it wasn't a factor in our decision not to hire you. We hired you because we didn't hire you because someone else was more qualified, or do you now have to prove why someone else was chosen over this person who about whom you learned this protected information. So what do I recommend companies do? How do companies get at this good information? The good information being the kind of reputational management stuff online, how people appear online, the good judgment, trash a former boss, bad, harassing photographs, whatever, while not learning this protected information, whether it's genetic information, disability information, someone's religious preferences. You can learn through what they post on Facebook, what have you. I recommend that companies, number one, do these background searches not as the only background screening tool in an applicant, but part of a more broad-based background screening program that companies like BackTrack can provide for you, number one. And number two, that you do them external to your hiring process. So what does that mean? It means that you train someone in your organization to do the searches, tell them what type of information it is you are looking for, and then train them to provide scrubbed reports that filter out all this protected EEO information, disability, age, religion, national origin, genetic information, race, what have you. Screen all of that out so that it never gets into the hands, never seen by the hiring manager or the recruiter, whoever is making the hiring, whoever is involved in the hiring decisions. But that good information, the quality information that you want to use, that you want to include in your decision-making process. Have they trashed a former company online? Have they disclosed confidential information? Do they appear to be a good cultural fit for our organization? Do they exhibit good communication skills? Do they post inappropriate or illicit pictures? That kind of stuff gets put in the report, while the protected EEO stuff does not. That's how you go about doing this process correctly, so that you don't put someone in the awkward position of sitting in a deposition chair while a lawyer is asking questions of, explain how it is you read this blog on Monday, and on Tuesday you made the decision to pass on this candidate and hire someone else who, by the way, maybe isn't as qualified. Really awkward position to be in as a company, and a very not complicated to set this process up the right way so that you can make sure that you get this information that you want to get while not taking on any unnecessary exposure. So with that concludes my prepared remarks. I am not difficult to find if you have any follow-up questions for me. My contact information is here in the slide deck. But frankly, if you just type John, I do manage my reputation online, so I know what you're going to find. If you type John Hyman Cleveland Lawyer or John Hyman blog into Google, you will find me pretty easily. I don't hide. You can find me on my blog, ohioemployerlawblog.com, on Twitter at John Hyman. I'm on LinkedIn and Facebook as well as at myersroman.com. I do want to, if there are questions, I'm happy to take questions. I was talking to Laura before we started, and this is now the third of 4 quarterly webinars we've done this year. The fourth, I think, will be more of a, we'll hit the high points of what we covered in the first 3 through a kind of a year-end kind of background screening and hiring kind of year-end tune-up checklist. So stay tuned for that as we approach the back end of 2015. So I thank you all, and if there's questions, I'm happy to take them if we can make that work.
All right, John, thank you very much. We appreciate your help once again with this. We do have a couple questions, mostly dealing right now with random drug and alcohol testing. The legality under the ADA, should companies be doing random drug and alcohol testing, different manufacturing facilities, things like that? Would you just touch on that again, please?
Yeah, all right, so safety-sensitive positions, manufacturing, for example, where somebody could get hurt. If it is a drug test, you're testing for illegal substances, the ADA doesn't cover it at all. You are free to do random drug screens to your heart's content. You can do them every day across the board if you wanted to. The ADA is not going to touch that. Alcohol tests, because the EEOC takes the position that an alcohol test is a protected medical examination, that is going to be limited by whether or not it is job-related and consistent with business necessity. And look, I can make the argument that in a safety-sensitive position, an alcohol test is always going to be job-related and consistent with business necessity. In a highly safety-sensitive position, the EEOC does not agree with me on that. They treat basically job-relatedness and business necessity more akin to a reasonable suspicion testing. That is, do you have reason to believe that someone is under the influence? And if so, then you have cause to test. And the EEOC takes a position that random alcohol tests across the board, not okay. I don't agree with them, but I don't make the laws, so you kind of have to go by what they say. In terms of prescription drugs, again, it's going to be really treated the same way as alcohol testing, because prescription drugs do have the ability to reveal protected medical information. That is, medical conditions, what someone's being treated for, what have you. Testing for prescription drugs as opposed to illegal drugs. Testing for prescription drugs is likely going to be considered a medical exam under the ADA, and therefore, if it's after someone starts working for you, you are limited to the job-relatedness, business necessity parameters of a during employment medical examination. So again, you're going to be pretty much limited to the confines, in that case, of reasonable suspicion testing more often than not, because the EEOC takes the position that otherwise you don't have this job-relatedness and business necessity, even in safety-sensitive positions. And again, while I disagree with that, I don't write the laws, so we kind of go with what the EEOC, we kind of go with their take on this issue.
Okay, thanks. Question here. I'm enjoying this question. I have small children and we talk about them 24/7 if given the chance. Is it wrong to ask someone's child's age if they bring it up during an interview? Could that be considered a hiring no-no? If they bring up their children, could you ask more about them, their ages?
I would not, and the reason is, I think it's the problem with doing that is it raises the potential for a female applicant, for example, who's sitting across from you, who says, "Oh, my kids. Oh, how old do they? Tell me about them." Well, Jimmy is 7 and Jamie is 5, and now that's applicant 1. Applicant 2 doesn't talk about their kids, doesn't have any kids. The EEOC's belief is that consciously or subconsciously, employers will prefer the applicant without children, because out of a stereotypical belief that they will be less distracted and therefore more dedicated to their jobs. And because of this potential subconscious bias, that most people will tell you it is a bad idea to ask personal questions about kids, families, and what have you during job interviews, because either consciously or subconsciously you might make certain decisions that you otherwise might not make absent that information. I know we want to be touchy-feely. I know we want to get to know somebody. I know we want to get the complete picture of an applicant before we hire them, and that includes things like their spouses and their kids and all that kind of stuff. And my recommendation, even though I sound like the lawyer buzzkill when I say this, is that we leave the personal stuff till after someone is hired, and we make the hiring decisions based on, business, business and employment-related criteria, and leave the tell me about your kids until you get to know someone after they're hired.
Okay, thank you. Another question with some concerns about a pre-hire physical test, such as a lifting assessment, things like that. Can you touch on those?
Yeah, as long as it is the medical examination, as long as it is post offer of employment. So you make an offer of employment conditional on the medical exam, whatever that examination is. As long as you give the same examination to all people in the same job category, you're not limited in what examinations you can give. So if you want to give a lifting examination, for example, that's fine as long as it is done post-offer, but before someone starts working for you, it's fine. After someone starts working for you, it has to be, again, it has to be job-related and consistent with business necessity only. And so you are much more restricted in the medical examinations you can give once someone starts working for you. But once you make an offer of employment and you make it contingent upon a medical exam, you can give any medical exam you want as long as everybody in the job category gets the same exact medical examination.
Okay. Next question. Can you run a background screen before bringing on a temporary worker? We do use temps for our warehouse, so could we run a background check on our temporary employees with their consent before we bring them on?
Sure, provided that you are, assuming you are following all the requirements of the Fair Credit Reporting Act, notice, consent, disclosure, what have you. And I recommend that you go back and watch our first webinar back from, was it January, I think? Was it January, Laura, the first one? Yeah, the webinar from January on the Fair Credit Reporting Act. That's going to limit how you do those background checks, but provided that you follow those, follow the procedures that the Fair Credit Reporting Act put in place, no limits on doing that before you bring a temp on.
Okay, and then our last question. With applications, resumes, job postings, how long do you keep these with your company? How long should you keep them on file, especially not hired people versus hired people? What are some thoughts on that?
6 years, and I'm going to tell you why it's 6 years. It's 6 years from, it's for employment records, all employment records. It's 6 years either from the date that you made the decision not to hire them, or for an employee 6 years from when they leave your employment. Because in Ohio, the statute of limitations for a discrimination claim for everything but age is 106 months. For race, sex, national origin, religion, disability is 6 years from the adverse employment action for someone to file a discrimination claim under Ohio's state discrimination statute. So for that reason, I always recommend that companies keep those records on file for 6 years.
All right, thank you so much, John. We appreciate your, once again, doing a webinar for us. And a reminder to everybody on the webinar, if you do wish to receive your one HRCI General Recertification credit, please answer the survey questions at the end. We will be emailing those certificates to you later this week. We'll also be emailing everyone a link to the presentation, which will include the slides that we showed today. So thank you once again, and we look forward to talking to everybody again in October. Bye-bye.